All right. Good afternoon, everybody. I'm Jen Welling, the Executive Director of the Illinois Environmental Council, and I'm excited to welcome you to this lunch and learn that we're doing today about the right to recreate law. It's now House Bill 1568, but we're going to cover a number of the legal issues surrounding river access, especially for paddlers, fishermen, and other people who want to enjoy our outdoor resources in Illinois, because we want to improve, we'll clarify the existing law. So we have Professor Eric Freyfogle from the University of Illinois College of Law, who is going to speak, as well as attorney Albert Ettinger. And I will send around their bios afterward as well, but I want to head into it. And Elliot Clay is going to be running slides. If you have questions, please maybe type them in the chat or raise your hand, and for Eric and Albert, we'll try to cut you off, or we'll take them at the end. Which would you prefer?
I would prefer to take them at the end.
Okay, cool. So we will take questions at the end, but you can feel free to put them in the chat at any time when they occur to you, and then I will ask them when we complete our review. And I'll send around materials afterwards as well, including a law review article that Eric has drafted about this. So with that, Elliot is going to share the slides and we're going to start presenting. So thank you so much for being here. And again, I'll put the CLE link in a few times for you to fill out. So thank you.
Okay, I'm Albert Ettinger. As Jen said, I'm a lawyer, a member of the Illinois Bar. I've represented a number of Illinois environmental groups for about 40 years now. I want to just introduce the topic. Most of this will be addressed by Professor Freyfogle. I just want to say there's been a great deal of confusion here. Water bodies are classified in the law for different purposes. One of them is the waters of the United States, as covered by the Federal Clean Water Act. Many of you may have heard of this because this is a big controversy, and it's now before the U.S. Supreme Court in Sackett versus EPA. That doesn't have anything much to do with what we're talking about today, but it is important. Another question is, what are the navigable waters for purposes of federal and common law? That's another interrelated issue. Finally, there's the public waters of Illinois for purposes of certain Illinois state statutes. I think Jen, if she hasn't already, is going to send you a copy of the Illinois Attorney General opinion, which interpreted the Illinois 1911 Rivers, Lakes, and Streams Act. And finally, there's a question as to what waters are covered by the public trust doctrine, which came up and was developed in Illinois in the old Illinois Central Railroad case of about 1870, but has been treated in many other recent decisions in a number of states. And it's important to realize that these classification systems are going to be separate, and to not confuse them, you got to look at what purpose we're considering before you use one classification. Some of them are related and some of them aren't at all. So with regard to Illinois citizens to use Illinois and access for other forms of important waters throughout the state. Now I'm going to turn things over to Professor Freyfogle.
Thank you, Albert, for getting us started here, and welcome. I'm pleased to see so many people sign up for this on astonishingly short notice. I suppose it indicates the current topicality of our subject matter today. So Elliot, go ahead and put the first slide up there if you would. Yep. So let me just start by trying to lay the groundwork here. I want to be talking this morning or today about two issues. which waterways are legally open to the public? And then in the case of those waterways that are open, how can the public use them? I do intend to talk for the most part about the first issue. That's most important, but I will have comments along the way about the second one as well. And I want to start off, though, explaining why this is such a confusing issue for people. In Illinois, the riverbeds, beds of all rivers, are owned by adjacent landowners, public or private. Since most of our land in the state is private, that means the riverbeds are privately owned. And that's true also of our non-navigable lakes. And this gives many landowners the sense that if they own the land, they ought to be able to exclude the public, or they should be able to curtail public rights. But in fact, in just sort of the basic law of easements, the public rights are considered the dominant estate, and what the landowner owns is the servient estate, meaning that public rights come first. To the extent the public has rights, they can enjoy those rights, and the landowner is not supposed to do anything that interferes with the public enjoyment of those rights. So there's a clear hierarchy of legal rights here. It is not as if we have sort of rights on both sides and we're going to be balancing them out. The law is very clear that the public rights are the dominant estate here. This is the basics of easement law. What makes this confusing is that there really are four relatively distinct bodies of law that bear on these two questions. Two of them, as we'll see, federal, one of them state law, and another one that's mostly state law, but it seems to have some federal element in it that still makes it uncertain to classify. Several of these bodies of law are not well known at all, and no effort really has been made to try to bring them together, which is the goal I set for myself in the article that either has been sent to you or will be sent to you. There is a tendency among lawyers, well-meaning one, to think that Illinois law alone dictates the answer to these questions. And with respect to Illinois law, it is basically the old common law in Illinois that provides the answers. This is the attitude that DNR, I believe, has taken. It largely thinks that the answer to these questions can be found in a 1905 ruling by the Illinois Supreme Court. And to the extent it's aware of other bodies of law, it tends to think that they're just consistent with that 1905 Illinois Supreme Court ruling. And as I'll say today, I don't think that's the case. Now, in fairness to DNR, I will say that the issue here is not for them just about public rights of access, that it really is about the regulatory burdens that have been imposed upon them. And so for them to admit that the public has broad rights in waterways just expands the amount of work they have, and they probably don't think they're well funded for it. And so they've got sort of a fiscal reason for wanting to view public rights pretty narrowly that may have nothing to do with any dislike of public recreation. So Elliot, can you go ahead and move ahead? So very briefly, the four bodies of law that I think apply to these questions are the following. There is the old common law inherited from England. And the law there had to do almost entirely with public rights to fish in waterways. It seemed to have nothing to do really with whether or not the public had physical access, whether it could travel on waterways. And the law that came out of England basically was that fishing rights depended upon the ownership of the land underneath the water. The public could fish when that land was owned by the crown. If it was privately owned, then the right to fish in those waters was owned by whoever owned the riverbed, typically the adjacent riparian landowners. English common law did ultimately decide that navigability of a waterway was based upon the tidal influence. Is the water one that was subject to the ebb and flow of the tides? If it was navigable. If it was, the crown owned the land underneath the water, and that meant the public had rights to use it. All other waterways were non-navigable, they were non-tidal. The public had no rights to fish in them, but the public did have rights to travel in them. Anything that the public could use, was actually using, was considered a public highway and open to travel. So Illinois embraced this common law, and frankly, to a fair extent, still does. The second body of law I want to talk about is the Northwest Ordinance of 1787. It comes as a surprise to many people to know that parts of that do still apply in Illinois. I'll talk about that, particularly the provision that makes all navigable waterways common highways and forever free. The third body of law is the Federal Navigation Servitude. It originated very late in the 19th century, arising under the Commerce Clause. I want to talk about that, but it does impose an overriding servitude on all waterways that are considered navigable for this purpose, and that overrides any contrary state law. And then there's the public trust doctrine, which the U.S. Supreme Court tells us is mostly a matter of state law. But there are various Supreme Court rulings out there, though, that say the trust doctrine imposes duties upon states that the states cannot get away from. The states are obligated to sustain and to look after. And that sort of leaves the sense that there must be some sort of basic federal law content to this as well. It's not entirely a matter of state law. Next slide. So the practical situation in Illinois is this. And let me apologize for repeatedly getting the name of the Illinois statute wrong. It is rivers, lakes, and streams, not lakes, rivers, and streams. So it tells the Illinois DNR to make a list of all navigable waters. And it has done so, as I say, I think basically looking to this 1905 Illinois common law ruling, which defined navigable waters pretty narrowly. There are very few Illinois Supreme Court rulings that deal with the navigability of waterways. I mean, in which the navigability of a waterway for public access was actually contested in the case. Facts were submitted and a court made a factual ruling about the navigability of a waterway. There are only two of them. And even in the 1905 one I want to talk about, the statements the court made there are arguably dicta. Interestingly, if you look at Illinois common law rulings, there are no waterways that are open to public fishing, except those in which the riverbed itself or the lake bed is owned by the public. Now, that's not a rule that DNR follows. It's not a rule I think that pretty much anybody follows, but that's what the Illinois Supreme Court has said in its most recent ruling, which is now more than a century old. DNR's list that it puts out as a result, omits a lot of waterways that are capable of supporting recreational uses. And in fact, it excludes many of the most popular canoeing rivers in the state. As I've already given you a hint about, the issue for DNR really isn't just about public access. It's about other regulatory burdens, responsibilities they have. And if they were to take a more expansive view of public access rights, they would be adding to burdens, and I can imagine they don't think they've got the funding to support that. Anyway, landowner interests, of course, often oppose public access. This is an age-old story going back literally to the Magna Carta in 1215 and before. There is constant tension between landowners who want to exclude the public and members of the public who want to exercise their public access rights. Governments over time, Illinois government, pretty much since the beginning, have favored landowner interests. Local law enforcement does as well. As I say, the stance that DNR takes also happens to allow it to curtail its permitting and river supervision work. So there's sort of mixed motives for them on that. Okay, next slide, Elliot. Maybe we'll get it.
Sorry, I've got a bit of delay on my end. Give me just a moment. Oh, there we go. I think that's right.
Well, let me begin, though, not with the common law, which of course has the longest historical record to it, but with the Northwest Ordinance of 1787. This, of course, set up the original Northwest Territory that included Ohio, Indiana, Illinois, Wisconsin, Michigan, and some of present-day Minnesota. And it included in Article 4 of it a provision saying that all navigable waterways and the carrying places between them shall be common highways and forever free. The Northwest Ordinance, of course, enacted before our federal Constitution was adopted. The ordinance was reenacted by the first Congress with just a little bit of tinkering to take into account changes in the federal government structure. And the substance of it was repeatedly reapplied in various federal statutes early in the 19th century to Illinois, to the Indiana Territory, to the Illinois Territory. When Illinois asked to enter the Union, one of the conditions on entry into the Union was that it can continue to comply with the Northwest Ordinance. There's been a lot of confusion over time, though, about which part of the Northwest Ordinance apply after a state joins the Union. And if you go back and look at old cases, you will find many of them that take the view that the ordinance stopped applying once a state entered the Union. And certainly many parts of it did, because a lot of the ordinance had to do with territorial governance before a state came together. And there were other provisions, one banning slavery, for example, that was pretty controversial. Anyway, the leading US Supreme Court ruling on the subject from 1921, in a case I want to talk about later because it dealt with the navigability of the Des Plaines and Chicago rivers. He says the navigation provision of the Northwest Ordinance does still apply. It was not capable of repeal by the states. And so there we have it. This provision making navigable waterways and the carrying places between them, common highways and forever free, is a federal statute that applies in Illinois, overriding any conflicting Illinois law. The Illinois Supreme Court had occasion to talk at some length about the Northwest Ordinance in an early case, 1865. And you see the definition is got there: a navigable river is a common highway free to the Indian in his bark canoe and every other vessel floating upon water. So it seemed to give it sort of an obvious interpretation. Next slide, Elliot. So which waterways are covered by it? Because the Northwest Ordinance does start off saying navigable waters. And if you take away anything from the talk today, I hope it is the recognition that the term navigable waterways is a concept that's defined in various ways. It's an issue that arises, as Albert said when he started, it arises under various federal statutes, under constitutional provisions. And you should start with the assumption that every time it is used, it will have a different meaning. There is no single definition of navigability that applies across the board. So if you're a lawyer and somebody says, is this waterway navigable? Your question ought to be, for what legal purpose? Because it might be for some and not for others. The broadest definition of navigable waterways is, of course, under the Clean Water Act. That's up, as Albert said, before the US Supreme Court at the moment. So that's one question that needs to be put on the table. What does navigable mean for purposes of the Northwest Ordinance? The common highways language of the Northwest Ordinance is very similar to the English common law term public highways. And that really included any waterway that people could use for any purpose. And so the hint would be that maybe the lawmakers were just borrowing that idea. So there were some 19th century Supreme Court rulings that later said that waterways are navigable only if they support commerce. Although if you look at the exact language, it defines commerce as being both trade and travel. At the time, as some legal historians have pointed out, the word commerce had a very broad meaning to it. It meant all sorts of social interactions. It wasn't just limited to economic trade of some sort. You can look up the Oxford, unabridged English dictionary, and it will tell you the same thing. Commerce meant just sort of social interaction. That was the meaning of it at the time. So I don't know that when the Supreme Court referred to commerce, it was meaning to limit the navigability of waterways. Anyway, the dictionary definition, as I say, there's only one definition, and that is navigable means capable of being traveled upon. So as an aside, the key language here of the Northwest Ordinance was applied by Congress to many, many other states. There is a federal statute cited in my article that makes this provision applicable in not exactly the same words, but substantively to all lands acquired under the Louisiana Purchase. It applied in other settings. When Florida came in, it was subject to the same rules. There are some states, Wisconsin is one, that has taken this language from the Northwest Ordinance and included it in its state constitution. And so we've got interpretations of the language arising from various states that have made it a matter of state law as well as federal law. If we look at the case law out there, there is not a lot of it, and the U.S. Supreme Court has not come down with any important ruling on it other than saying it does apply. The interpretations that are out there of the key language do seem to apply it broadly to protect recreational uses and other travel, not just trade. Many of the cases and commentators point to this carrying places language, which suggests that the ideal Congress had in mind when it wrote it was people with very small boats, things that they could put on their back and carry. So it was not meant just for larger vessels. The issue, though, I would say remains unclear. Not that there's disagreement among the cases that they're out there, but the body of case law isn't all that substantial. It would be good to have maybe some more rulings on the subject. But my conclusion is that a literal and original interpretation of this language supports protection for all forms of travel on water by any sort of vessel for any purpose. The language that seemed to limit it just to commercial activity dates from the 19th century when Congress was worried about its, when the Supreme Court believed that Congress's Commerce Clause power was fairly limited. That Commerce Clause power, of course, has been broadened considerably since then. And so my conclusion would be that the Northwest Ordinance ought to be written just as it's literally written, meaning any sort of navigability is going to be protected. As for what uses are protected, it's hard to say. The argument can certainly be made that people who traveled on rivers would have freely fished on them. And that would have been consistent with this kind of spirit of liberty that pervaded in the United States at the time, a spirit of liberty that we've pretty much forgotten about, that people used to be able to wander and hunt at will, even on private land without the permission of the landowner. But I would have to say the bottom line is not clear. Maybe fishing is covered, maybe it isn't. The argument against fishing being covered here would be that the language, the public highways seems to be similar to the English law. And in England, as I say, the public had rights to fish only in tidal waters that were navigable. But let me move on then to the federal navigation servitude. This is basically an overriding interest that protects the power of Congress to manage navigable waters. It's mostly used to insulate the federal government from having to pay compensation when it does something in a river that causes economic loss to riparian landowners. There is a fair amount of precedent under it as to what it means in terms of public access and fishing, and all of it points in one direction. All available precedent says that it keeps navigable waterways open to public use, including fishing, despite state property laws. And I think it all suggests that any waterway capable of supporting recreational uses is open as a matter of federal law under the federal navigation servitude. So next slide, Elliot. So this brings me to the public trust doctrine. It has a very old history to it. It's very much wrapped up in the old idea that the Crown owned land underneath navigable waterways, and that because of that, those waterways were subjected to a public trust. The Crown didn't own this land in a personal proprietary sense. It wasn't the king or queen's personal property. It was land that the queen held as sovereign, and it was subject to trust duties that allowed the public to make use of it. Under the equal footing doctrine here in the United States, one of the more obscure provisions of our Constitution, as each state entered the Union, it gained title to the land underneath these navigable waterways, subject to these trust duties. And by then, navigability for this purpose in the United States meant anything navigable. In fact, if you could navigate it, in fact, it was navigable waterways. The term was not limited to tidal waters. The U.S. Supreme Court, as I said, has several times said that the states, as they got this land from the federal government, took it subject to trust duties that they were bound to respect. But it has also said more recently that the public trust doctrine is basically a matter of state law, and the states can develop it as they see fit. The leading U.S. Supreme Court precedent here from 2012, as I say, seems to state pretty clearly that states can take charge of this public trust doctrine and develop it as they see fit. That they can apply it to waters that are not that don't qualify under this navigable for title definition. They can apply the trust obligations, trust duties, public access rights to a broader array of waterways. And many states have done so, by the way. They've applied it even to waterways that are overtly non-navigable. So states, as I say, have developed and applied the doctrine in a wide variety of ways. Many, including Illinois, have applied it to lands other than submerged lands underneath waterways. There are a fair number of states that expressly embrace a recreational use definition of navigability, meaning the public trust doctrine applies in any waterway that's capable of being used for recreational purposes. Others, though, do require a showing that a waterway be suitable for commercial use, although what that means is often not clear because, as many cases have now said, canoe rental is itself a business. Being a fishing guide is a business. Leading rafting or kayaking trips is a business. And so recreational and commercial have sort of merged together. So in the case of waterways that are subject to the public trust doctrine, there is pretty broad agreement that it includes public rights to boat, to fish, to wade, to swim. And these are all independent rights. The fishing doesn't have to be fishing from a boat, for example. It can be just fly fishing standing in the water. And the swimming doesn't have to be from a boat either. There are a few states, Wisconsin among them, that also allows public hunting here. I don't know any state that allows trapping. That was an issue in one Wisconsin case. Next slide, Elliot. So the Illinois Supreme Court has a fair number of rulings that apply the public trust doctrine, but all of them apply to or disputes that arose dealing with the Lake Michigan shore or to land fairly close to the Lake Michigan shore. The recent controversy over the Obama presidential library, for example, was a public trust doctrine case that went up to the Seventh Circuit. So the doctrine in Illinois does apply to various types of public lands, lots of rulings dealing with Lake Michigan shoreline. The precedents from there do make it clear that the public trust doctrine in Illinois protects public interest pretty broadly and strictly. However, a big however, the Illinois Supreme Court has never heard a case applying the public trust doctrine to inland waterways. Which is, I suppose, why the DNR and lawyers generally don't take it into account when they think about public access rights in Illinois waterways. There's no question, however, that the public trust doctrine does apply to inland waterways. It's just we don't even know exactly what it means. What we have to do is to try to glean evidence here as best we can from rulings that deal with its application along the Lake Michigan shore. So there is a 1976 Illinois Supreme Court ruling with very strong dicta favorably citing rulings from elsewhere that apply the doctrine to protect recreational uses in inland waterways. So we've got that to go on. And then there's an earlier case that might be useful on this subject as well. So there's a big void here. And I think that's one of the causes of today's confusion. In many states, when people say, oh, what public access rights are there? They look to the public trust doctrine as developed in that state. Illinois, you look for that and you don't find anything that deals with inland waterways. As I say, though, the public trust doctrine clearly applies. Illinois is obligated to have it. It does have it with respect to Lake Michigan. And I assume that at some point, maybe soon, the Illinois Supreme Court will come down with an authoritative ruling about how it applies to our inland waterways. So this brings me to the fourth of the four bodies of law, the old common law. It is surprising how little law Illinois has on this subject. The cases are dated, so much so that I think the common law is very much open for reconsideration by the Illinois Supreme Court when it has the occasion to do so. In fact, there are really only two appellate decisions handed down by Illinois courts, both by the Illinois Supreme Court, that deal with clashes over public rights to access a particular river, leading to rulings on the navigability of that river for purposes of public access. And both cases involve peculiar facts. And of course, neither one paid any attention to federal law or to the public trust doctrine. An early 1870 ruling involved a largely dry creek bed or swale that occasionally had a little bit of water in it, and somebody upstream wanted to float logs down it, during the occasional time when there was water there. And the court said that was non-navigable. It didn't really define navigability with any clarity. So that leaves us with this 1905 ruling. It involved, interestingly, some dry wooded lands away from the Illinois River that were inundated by some waterway construction. The lands were quite far from the river channel, and access to this water was being sought by hunters who wanted to sort of come in and hide behind the shrubs and the trees and so on while they were going after their waterfowl. And the main ruling of the case was that hunting is not a public right in navigable waterways. Even in waterways that are clearly navigable, the scope of public rights does not involve hunting. So having reached that conclusion, the court really didn't have to make an authoritative decision about whether this particular water body was navigable. Next slide, Ellie. This 1905 ruling, however, Schulte versus Warren, did talk at length about navigability. And in fact, it is the language from it that I think people point to when they explain what Illinois law is. So in the ruling, the court said a waterway to be navigable must have sufficient depth to afford a channel for useful commerce. Not clear, of course, what commerce means. It is not enough for a water merely to float rowboats or small launches or to allow hunters and fishermen to pass over it. So that's the key language from the ruling that people pick out, and they take that and think, well, that's the law of public access in Illinois. And it is, in fact, the last thing the Illinois Supreme Court has said on the subject that really was very clear. The facts of the case were sort of odd. What the court said was that since it didn't need to decide navigability to resolve the case, it decided that hunting was not a public right. It merely just said, well, lots of the places here have enough water to make them navigable, but we're not going to tell you which ones we are because we don't have to resolve the case. Very odd, because this was not a navigable waterway, was not a waterway at all in its original condition. There's many surprising things about that ruling. Anyway, there was a 1909 Illinois Supreme Court ruling not involving public access, where the court said that the Des Plaines and Chicago rivers were not navigable as a matter of Illinois common law. Interestingly, essentially the same facts came before the U.S. Supreme Court in a 1921 case. Applying the Northwest Ordinance, the U.S. Supreme Court said, no, the Des Plaines and Chicago rivers completely all the way to the mouth are navigable. And it mentioned the Illinois Supreme Court ruling in passing, but didn't seem to pay much attention to it. Another case comes to the Illinois Supreme Court just 2 years after that. Again, it's not a public access case, but one involving navigability. And there the court says, aha, well, we've been sort of slapped by the Illinois Supreme Court for not paying attention to the Northwest Ordinance. We now will. The Northwest Ordinance applies in Illinois. The case was resolved because the court decided that a particular landowner had dedicated a waterway segment to the public. So it was open to the public without regard to navigability. So there never was a ruling about it. But the court did seem to recognize that maybe it had made a bad ruling back in 1909. Next slide, Elliot. So there have been a few Illinois Supreme Court rulings over the years that presumed that particular rivers either were or were not navigable in disputes where the issue was not contested. And I think those opinions really provide no guidance then on the issue of waterway navigability for purposes of access. I would include in the list the 2022 ruling of Holm versus Kodat, because the parties to that ruling both agreed that the waterway was not navigable. And so the court never had occasion to question whether it was navigable. And I don't think the ruling then therefore stands for much of anything on that issue. There was a 2015 unreported federal court ruling dealing with navigability. The court there sort of mixed Illinois common law and public trust doctrine principles to embrace a recreational use standard. And I think Albert is, I think Jen will be sending that out to you. It says public access in Illinois is not limited to river segments covered by the navigability for tidal rule. Anyway, interestingly, as an aside, there are various Illinois Supreme Court rulings from 1842 to 1905 that say the public has no rights to fish in Illinois rivers and lakes unless the underlying land is publicly owned. That includes our biggest rivers, the Illinois River, I suppose the Mississippi River. So there you have the Illinois common law. So next slide, Elliot. So the Illinois Rivers, Lakes, and Streams Act is relevant on this issue. It does vest DNR with the duty to safeguard the state's and citizen interest in all public waters, a term that is defined very broadly in the statute to include not just navigable waterways, but all of their non-navigable tributaries and all adjacent wetlands that have a surface water connection to a navigable, to a waterway. So it's an extremely broad definition. I would say quite comparable to the Waters of the United States rule under the Clean Water Act. The statute, if you haven't read it, I would encourage you to do so because there's language in there which is really quite surprising. The legislature repeatedly says to the DNR to do everything possible to maximize public uses of these waterways and to safeguard public interest against even the slightest intrusions. And when I see a statute that has this pleading language over and over again that's been added, it makes it clear that the legislature has told DNR to do this once. It didn't get done. They told them again. They told them again. And they keep trying to be more and more clear, thinking that if they were just abundantly clear, somehow it would get done. And it really hasn't been done. I think, frankly, the DNR continues to misread the statute. They did get a 1987 opinion from the Illinois Attorney General, which interpreted it exactly the way I have said. But it doesn't seem to sink in. So consistent with what I would describe as its pro-landowner stance, DNR claims that any expansion of public rights beyond what is currently recognized by the state, meaning beyond those waterways set forth on the DNR list of navigable waterways, would require payment to landowners to avoid takings. Next slide. A taking here, of course, means taking of private property without the payment of just compensation. Well, let me try to bring this together and we can open it up for questions. So as I read the law here, both the Northwest Ordinance and the Navigation Servitude, which as matters of federal law do preempt contrary state law, that I think they open to the public all waterways that can sustain recreational watercraft. And the Navigation Servitude, maybe the Northwest Ordinance protects public fishing. The Illinois Public Trust Doctrine, without question, applies to inland waters as well as Lake Michigan shore. The law, as I say, is poorly developed, undeveloped, but the best guess is that it would protect recreational uses pretty broadly, including swimming, wading, and the like, because those are protected by the trust doctrine in Lake Michigan. The legislature itself can elaborate the public trust doctrine. This is not just a body of law that's left to the state Supreme Court to develop. And it's possible to interpret various sections of the Illinois Rivers, Lakes, and Streams Act as having done that, of pushing public rights in all public waters as far as they can then go. As for the fourth body of law, the Illinois common law, frankly, apart from the public trust doctrine, and I should note that in many commentaries, the public trust doctrine is described as a matter of state common law. I choose to sort of separate it out because it is a subject matter that the legislature can act on. In Illinois, as I say, the legislature may have already done that. And it seems to have some core federal content to it that the state needs to respect. So I think it's best thought about as being a separate body of law. Next slide. With respect to this worry about the takings, I don't actually think that there is any chance of it. Although who knows with the Supreme Court. The major on point ruling by the US Supreme Court came recently in 2021, the Cedar Point Nursery case, where the court really broadened quite considerably the protections that landowners have against new state laws that authorize physical invasions of their property. It's important to note, however, that a new law invades a property right only if it's clearly established. And the law has to be clearly established under some body of law other than the Constitution. As the Supreme Court has repeatedly said, the Constitution doesn't create property. There is no federal constitutional property. It only protects property that arises under and is recognized as clearly established under some other law, state law usually. Illinois landowners have no clear right to exclude recreational users. You might say the issue is debatable. It is certainly debated, but you can't claim that they have a clear right to exclude recreational users. Also, the US Supreme Court, in some strikingly strong language by the late Justice Scalia, said that there is no taking when a judicial ruling merely clarifies law that was not clear. Even, he says, when the state Supreme Court clarifies it in a way that is surprising to people. Furthermore, if for those of you who know something about the subject of regulatory takings and the jurisprudence there, this last point will be significant. But both the navigation servitude and the public trust doctrine have been repeatedly recognized as background principles of state property law that can justify limits on landowner powers. Next slide. So House Bill 1568, very quickly, essentially what it does is says the citizens of Illinois should be able to enjoy all the public rights that they currently have under these four bodies of law. And therefore it's pushing back against DNR and against other understandings of public rights that want to curtail public access to waterways that seem to meet the definition of navigability under this 1905 Illinois Supreme Court ruling. So the 1568 does actually mention expressly the Northwest Ordinance, the navigation servitude, and the public trust doctrine. It states that those bodies of law brought together protect recreational uses in all waterways that are capable of supporting those rivers. It does go on, however, to say that if a landowner thinks otherwise, if there is an owner of submerged land on a waterway segment that says, gee, I don't think my waterway segment is in fact open to public use under current law, meaning navigation servitude, Northwest Ordinance, public trust, the landowner can go to court, can say that. If you prove it, then the public doesn't have access. And that was put in there, I think, just to try to make even more clear that this bill would not work any sort of uncompensated taking of private property without just compensation. And there's other provisions in there that are out to protect legitimate landowner interest and to respond to DNR worries that the bill would increase its workload. Next slide. So let me finish up then with it. This is our last slide. Just a few minor points. Navigable lakes in Illinois, meaning basically those that were meandered by early surveyors, the outline put in. The public can use the lake surface of them because the underlying land is publicly owned. Non-navigable lakes, Illinois has the unusual rule that anyone who owns property on the edge of a non-navigable lake can use the entire lake surface. You're not limited just to using the portion of the lake surface that overlies submerged land that you own. Old quarries and other human-made lakes. This has been, interestingly, sort of the hottest litigated issue about public access in Illinois of late. old quarries where people who maybe got a house on them want to use the whole water body. Those, of course, are not natural lakes. They are closed to the public, meaning you have to own the land underneath them to have public access. But Illinois does have this interesting rule about the artificial to natural rule that even an old quarry through public use over time can become a natural body of water and be open to public use. Obstructions to waterways are public nuisances, both civil and criminal. There's an Illinois statute that specifically makes it a crime to obstruct a navigable waterway. The only precedent on the subject says self-help is still available. So if there's obstruction to a waterway, you can just rip it down. Whether the Supreme Court would follow that rule today, I don't know. There is an important, I think, little known Illinois Supreme Court ruling from 1970 that says any member of the public can enforce public trust duties in state court without need of any special injury to get standing. Just being a citizen, a taxpayer, is enough to give you the ability to enforce public trust duties. A footnote there, that is not true exactly in federal court. Federal court, you still have to follow federal court standing rules that do require an actual injury for the plaintiff involved. So that brings me to the end. I'll turn it over to you,
Great.
Jen.
Thank you so much. So I did have one question in the chat. And Albert, I put you on mute, so you'd have to take yourself off to answer it. And others, feel free to put a question in the chat or raise your hand. We do still have 10 minutes left, so I'd love some discussion here. And the question I had in the chat was for you all to give us some thoughts about how this applies to the Lake Michigan shoreline. And I think you covered a little bit with the public trust doctrine, but it would be great to cover Lake Michigan more specifically.
So Lake Michigan shoreline is a different case because the land underneath there is publicly owned. And there are a lot of public trust doctrine cases that deal with, well, the origin of the public trust doctrine, as Albert said, I mean, what is looked upon as the Lodestar case arose in the Lake Michigan waterfront. And so they are open for a wide range of public uses. I'm not sure what the question is. A lot of the litigation about the Lake Michigan shoreline has been when is it possible for the state or the city to authorize putting fill material on the waterfront?
Well, that's public
sometimes
trust
that's been
doctrine.
allowed. I mean, Albert may know about that. Then there's other cases that deal
Well,
with
the
other
Loyola
property.
landfill.
What's that?
Well, Judge Aspen ruled against Loyola in the Loyola landfill case based on that, and a number of public trust doctrines. There's also IDNR, which we're not sure about their position on other waters, has taken the position that the bottom of Lake Michigan is regulated by the state of Illinois, and you require an IDNR permit as well as an Army Corps permit to build any sort of erosion control structure or other structure in Lake Michigan.
Yeah, so I don't know, Brian, if you want to take yourself off mute. Brian wanted to maybe ask a more narrow version of the question.
Thank you, Jen.
Oh, you are a little,
Am I echoing?
you're echoing, yep.
I won't torture you.
Okay. All right, you feel free to put that in the chat because you are echoing. So, cool, actually. So there are a couple of questions about where this is legislatively in particular better. So let me ask Elizabeth asked a question regarding the right to recreate. Are there any particular battles ongoing now over this right? And I think that's a question the two of you could answer. And if folks are experiencing stuff locally, put things in the chat. And then there was a request for talking about where 1568 is that I can do with Elliot follow-up. But do you guys want to answer just what the particular battle is ongoing right now with the right to outdoor recreation in Illinois?
Well, a number you've heard from the legislators, but the big issue had to do with people who were floating on the DuPage River, and that has been an issue. But it's arisen around the state. The Home versus Kodak case really doesn't raise the issue, although it was given more attention than it did. The parties stipulated that the water was non-navigable, so they kind of took their case out of this, but it was still read by some as important on this issue. But it's an issue across the state. There's a lot of waters that you can clearly canoe on, but it is claimed by some people you should not be allowed to canoe on.
So related, there is another question in the chat about the removal of man-made lakes, and he it seems like in the last slide we said those man-made lakes are no longer public, and a question about what removed man-made lakes from the definition of lakes that are public. So I think this is a little related. I don't know, Eric, if you want to address that.
Well, so they never would have been open to the public. So this is private property that's been inundated deliberately. Yeah, so I mean, the public would have access to navigable waterways, and that means things that were waterways. It doesn't really apply to things that are artificially created. Whoever created them has the right to uncreate them, and to control access to them. So the only exception to that is this artificial to natural rule that the Supreme Court has developed in a series of cases. And that really requires a showing that it's been open to public use for quite some decades, if not generations. It's been treated as public. People have made decisions based upon the assumed public access to it. And at some point, a court may say, yes, it is now a natural body of water. But short of that, right, human constructed lakes don't really qualify. I say Illinois is among the very few states that follows the rule that I described in the case of non-navigable natural lakes, allowing anyone who has land on the edge of that lake to make reasonable use in common with other riparian landowners of the entire lake surface. The rule elsewhere, for the most part, and there have been recent rulings on the subject in both Indiana and Iowa, for example. Only you are limited to using only that water that's above the submerged land that you own. So that makes it sort of awkward.
Well, I'm not disagreeing, of course, although I do want to point out the definition of lake here is a little unclear. If you dam a navigable water and create a lake out of it, say Lake Peoria, you don't remove its navigability by doing that. So we have a whole lot of unnatural lakes in Illinois that were made in waters that were themselves navigable.
Sure. Yeah. So Albert, I would say there, my assumption is, and maybe some of you can correct me if I'm wrong, my assumption is that the land underneath that water is now publicly owned. The public would have acquired the land. And if that's the case, then the public's going to have access to it on that basis, subject to whatever regulation might be put in place by the governing body that owns the land. So I mean, they have the rights of landowners and might be able to control it. But my assumption is that those waters are open based upon public ownership of the land itself.
Well, so related, there's a question in the slides, we've talked about the DuPage River, and, I know we've heard from the Kaskaskia, the Middle Fork of the Vermilion, some of these questions where they're not public bodies of water, but they're certainly navigable under the federal definition. There's a question about how access to waterways fits into the picture here. And I will say, just to add a detail to this, we know that, for example, on the DuPage River, IDNR will actually fund access points for people to take watercraft in and out, despite that it's not a public body of water. And there's been some question about, the rules behind those grants. But do we want to talk about access to the river itself?
Sure. Yeah. So, you can't be crossing somebody's private property to get to a river without their permission. Permission, it'd be good to have express permission. You could say it's been a implied permission if people have been crossing some particular spot to get to waterway over time and landowners have not objected to it. The criminal trespass law in Illinois, by the way, requires that a person be notified in advance that they're not allowed to cross property, either personally given notice or with no trespassing sign. So if there's no trespassing signs and you've never been notified about it, you're not going to get arrested for criminal trespass. Civil trespass is actually hard to say. There's so little criminal or civil trespass precedent in Illinois. It certainly used to be the case for generations that the rural countryside generally was presumed open to public access unless landowners took specific measures to close it off. And there's some Illinois Supreme Court opinions out there that say that very expressly. You can get access to it at any road easement will allow you to get off and get down there. But otherwise, it's going to be public access, public ownership put-in points.
I think this might be a good place here. Just, we've talked about trespass, but when it comes to liability on public property, there's actually a really big benefit to purposely opening up your land to the public for recreation, since there are liability exemptions for outdoor recreation. So I'll add that part in. Okay, so there's a couple of specific questions here. Specifically, Professor Freyfogle, how would you define sustained recreational watercraft? What about intermittent flow or flow after a rain?
Yeah. So, well, it's a line drawing task that's mighty difficult to take on. That language isn't clear, but I'm not sure in any language would be very clear. I suppose it could be rewritten so it gives a certain number of weeks of the year that it would be open, or a certain number of days even. Short of that, I'm not sure how you would go about trying to be more clear. It certainly is ambiguous. There's no doubt about it. But I think it's just the nature of the challenge. So it's not much of an answer, but I'm afraid it's the best I can offer. Can I interject one thing? I know we're just about out of time here, but I've been sort of hard on DNR, I think, but I want to maybe say something more on their behalf. And that is, if you read literally the Rivers, Lakes, and Streams Act, particularly looking at the broad definition of public waters, which I've given you here, and then turn to section 18, that requires a DNR to give permits for anybody who puts any film, does anything. I just want to read a couple sentences there because it's just an astonishingly broad statute that if read literally, if read the way it's written, would impose a tremendous burden on DNR. Because it essentially, it makes it unlawful to put in not just any fill or deposit of earth, rock or sand or other material, any refuse into any public water, to build any wharf, pier, et cetera, to build or commence the building of any other structure, or to do any work of any kind whatsoever in any of the public bodies of water within the Illinois without getting a permit from DNR. And when you realize that public waterways includes every non-navigable stream, every adjacent wetland of some sort, I mean, this is very much akin to the Corps of Engineers 404 permit program. And you can see that DNR, without a massive increase in funding, is not going to want to embrace an interpretation of the statute of public waters that imposes that kind of burden on it. And I don't know that the landowners of Illinois would put up with it. So in my mind, I think it would be appropriate for somebody to take a real look at that whole statute and consider rewriting it, because it just the pieces just don't fit together very well. And I think DNR is caught in the middle, and I'm sympathetic for their plight.
Thank you. Well, let's take one last question, and then I'll have a couple announcements. I did put the CLE link in there, and then I'll talk about HB 1568 and where it's at. Oh, Sorry, Albert, you're a little behind there. But the last question, are you aware of any discussion or case law dealing with ownership of sediment?
Um, so, the actual physical stuff on the bottom of a river is owned by the landowner, and includes anything embedded in it, by the way, mussels, for example. And I would think sediment would qualify as accretion. And so it's going to be owned by the landowner, as the rock, any gravel on a riverbed. All of that is owned by whoever owns the land, which in the case of Illinois is usually going to be a private landowner. I mean, the Illinois statute here, among the provisions, which I find astonishing, is the one that says you have to buy any sand or gravel that you're taking from a riverbed, get a permit for it and pay for it, which I don't understand how that can be, because it's part of your private property. To begin with, it doesn't belong to the state. I mean, the state might regulate the activity, but it can hardly be charging you money for what you already own. So my answer would be, I think the sediment becomes part of the land where it settles, and it would be owned by the landowners.
Cool, thank you. Well, so I think that's all we have time for. And I just want to offer a big, huge thank you to Albert Ettinger and Professor Eric Freyfogle here, especially for drafting House Bill 5068 and working as volunteers on this really important clarification. The bill right now, it didn't get out of House Exec Committee, and we're uncertain of its future this year, but we are going to continue. I know this is really important to Representative Yang-Rohr, Senator Ellman, and many of the sponsors of the bill, and they want to see progress on it quickly, particularly as it has to do with DuPage River and the significant just outdoor recreation on that river and its ability to continue. And so we are very heavily trying to see if there are other pathways where this can be considered, talking to other stakeholders. And I think, one of the reasons we held this lunch and learn was, Eric brought up there's sort of two camps here. There are the camps that don't understand this yet. And then there are the, camps that are worried about individual property rights, and which is part of the don't understand this camp. So part of this is we'll record this, and we're trying to make this issue more understandable for folks. So it is 1:05. We're going to stop the recording, but I'm going to put the CLE link one last time into the thing. Please make sure you fill it out today. I'm actually going to try to get it. And for those of you who are looking to get CLE, we're actually going to have another one March 31st about with Blacks and Green on utility shutoffs and affordability with relating to energy. So we'll send a note around. I've got all of you attorneys on my list now to let you know we're trying to offer some of these, or if you want to teach one because you have an interesting environmental topic, we're trying to especially make environmental advocacy law more accessible to attorneys that could have an interest. So this was super interesting. So just a huge, huge thank you to Albert and Eric. I put the action alert in the chat for House Bill 1568. This is a really, really important concept, important clarification that impacts so many of us. So I hope you'll take action and let others know about this, and let us know if you have any feedback. So thank you and have a great afternoon.
Thank you.
All right. Bye, everybody.
Bye.
Thank you. Thanks. All right. I'm going to stop the recording, and have a great afternoon, everybody.